I already have this up and loaded and ready to rock and roll. I'm going to go over some of the basics and go through this again, very specifically as well. And again, giving you potential issues that mistakes that you just don't want to make. So let's go ahead and get into this. So I already have the pre-filled with the caption information. And the only thing and comment I want to make about this is, this part is obviously pretty straightforward. You're just going to put your contact information, court location, and so forth. And, but what I do want to call out right from the get-go, and I'll probably say this 2 or 3 times during this talk, is how you guys list your names here on the petition and all paperwork moving forward. So I really want to focus on this before we get started on how to fill out this form. Whatever name you use on this petition, you need to use on every other form, specifically the summons. But again, all paperwork throughout, you're going to want to continue using the same names. What we end up seeing, I want to showcase this real quick, is that on the petition, and this usually happens because people are pre-filling their forms by hand, or they're typing them all individually. See, with our software, once we enter you into our system, the names populate automatically the same throughout. So it's not an issue for us. But we see is when people come to us for help and the summons and petition don't match. So what they'll do is they'll have, Jane Smith here on the petition, and they'll get through this form. It's 3 pages and probably took you 5 or 10 minutes or longer to get through this. And when they get to the summons, they come in here and like, oh, Jane, R. Smith. They just forget what they used. They use a middle initial or a full middle name or something hyphenated. They'll change it up essentially. One to be something different, and it has to be identical as the summons and petition. So I hope I made that clear. So let me just correct that. All right, so let's get into the petition. And again, this is so you can follow along. If you have the form, on another screen and you want to fill this out as we go, or you have printed these forms, you can just follow along. I'm not going to go too slow, enough that you can probably keep up, but you can always, later on, you guys can find this video and rewatch it and pause it, etc. So we are going to start here at the top, petition 4. We're going to assume dissolution of marriage. It's probably 99% of the cases we file are dissolution of marriage cases. We do handle some legal separation cases and obviously the domestic partnerships, but you're going to want to mark what's appropriate here. So in this case, dissolution of marriage. You're not going to, one thing we see people do is marking multiple boxes here, and that will be an issue for rejection. So you're going to select one or the other, dissolution of marriage or legal separation. So this would be incorrect. And you also aren't going to want to do this. So we have parties who have been in a domestic partnership and then they later got married. So we'll see them prepare the petition this way. And that is also incorrect. You're only selecting one at a time. Now, if this is your situation where you have a domestic partnership and a marriage, you're just going to check the marriage box because that will dissolve the domestic partnership. Pro tip there. Okay, legal relationship. Okay, again, we're going off the fact that this is a dissolution of marriage, again, which is 99% of the cases we file. You're going to mark, we were married. Residency requirements. It says petitioner or respondent has been a resident of this state for at least 6 months and of this county for at least 3 months immediately preceding the filing of this petition. So you're just going to mark if this applies to you or to your spouse or to both of you. Only one of you has to qualify. So if your spouse is in another state, that is fine. As long as one of you lives in the state of California, you can file in California. And if you're the petitioner and you live out of state, but the respondent still lives in California and you want to file in California, you just mark the respondent box. So as long as one of you qualify, that's the way you will go on this. Okay, statistical facts. We're going to jump down to here. Date of marriage, okay, month, day, and year. You're going to fill in the blanks here. So we'll just plug in some dates and then date of separation. All right, so one thing aside from helping you guys fill out this form is going over again some of the mistakes people make or things that people leave out. So people say, Tim, we have not separated. So what date would I use? If that's the case, and like our clients, at least, I don't know, 80% of our clients are still living together and they have not physically separated, not even as much as moving into another room, and that's totally fine. If there is no date that you talked about in the past or that makes sense, or maybe 2 months ago you said, yeah, let's get divorced, use that date. But if no other date makes sense, just use the day that you're filling out the form as the date of separation. It needs to be the date filing or sooner. It cannot be a date in the future. You can't file this today and say the date of separation is 2 months from now. It won't work. Another mistake people make is they do not put the years and months in here. So, once you've put in your date of marriage and date of separation, make sure you do put the years and months. And usually it's the people that left this blank that will then leave this blank. So, but some people just skip right over this section because there isn't a checkbox next to it. So date of marriage, date of separation, years and months of the marriage. The minor children section here, either there are no minor children, or if there is, names as you want to write them down. So whether you use first name, middle initial, last name, etc. Again, same thing with we talked about is the names of petitioner respondent. When we get further into the paperwork, we do want to make sure that we present the names of the children exactly the same as we have them on the petition. So if you use first, middle, last, make sure you do that throughout. Date of birth, age. Okay. The next thing is if you have additional children, so we have spots for 1, 2, 3, 4, 5 children. I think in the 10 years we've done this, I've only had one case where we had more children than this. I think there were 6. So you can do a continuation form if you need to. That's not a problem. And then also they've included, this is on the newer form now, well, of 2020. This hasn't been updated this year, but you can now include if a child has not yet been born. So if you're pregnant and you're going through divorce process, you're going to want to mark this box as well. And you're not going to mark, if this applies to you, still mark B. You're probably not going to have a child's name. If you do, that's great. You obviously don't have a date of birth, but you would just mark this and then a child who's not born, because this number 2 is off of this B here. Okay. This is one thing that will cause your judgment to reject. This petitioner and respondent signed a voluntary declaration of paternity. So if you're filing for divorce and one of your minor children has been or was born before the marriage, so their date of birth occurred before the date of marriage, you need to mark this box. It says petitioner respondent signed a voluntary declaration of paternity. So when this, and your child may be 14 and still been born before the marriage, what you're looking for is this declaration of paternity. And what that is a document you would have signed in the hospital. It's not the birth certificate. It's literally called a declaration of paternity. And you're going to need to locate this. If you don't have this, we have a way, and because like I said, if your child's 14 and you probably don't have this declaration of paternity, most of our clients don't or unable to locate it. We are able to draft up a stipulation that basically has the same language as the declaration of paternity, which the court has accepted in the past and currently. Okay, page 2. You're going to mark legal grounds. So why are you getting divorced? In California, it's just irreconcilable differences. So in this case, we're doing divorce for irreconcilable differences. There's a couple other reasons to, not for divorce, but for other reasons, nullity and voidable marriage and all these. We're not covering this. I'll be honest with you. I've maybe done 2 nullities in 10 years, and we've done thousands and thousands and thousands of divorce cases. So we're really only just focusing on divorce for irreconcilable differences, or if you did legal separation versus divorce, you're going to mark the legal separation based on irreconcilable differences, because there is no causation needed for filing for divorce. And again, you would not want to mark both. Okay. So we're going to fix that. Custody. If you have minor children, do not skip this. We see parties skipping this for some reason, and you don't want to skip this. You want to make sure that this is complete. So it's going to be your option for what you want to select here. Remember, everything in this petition are just requests. If I can direct your attention here, petitioner requests. So these are not court orders. They're just, you're just saying, this is what I would like to ask. If you guys are going through an amicable divorce, like with the clients that we help, even if you said, you want full legal and physical custody, but then later you didn't realize that was a mistake and you want to have joint legal custody, in the settlement agreement, we can simply say that you want joint custody. So this does not lock you in an amicable divorce. It's just maybe what you requested at the time petition changed, and you can, through the settlement agreement, it will supersede what you put in the petition. So not a big issue in amicable cases because the settlement agreement will supersede this. So with our clients, mostly we're just going joint legal, joint physical. And I do want to make a comment on this. Even if the timeshare, this is what I tell folks, that the joint does not mean 50-50. Joint just means equal access. So we do mostly joint legal and physical custody orders, and maybe one parent has 95% of the timeshare. So just the difference is if one party has physical custody, the other one is forced to have child visitation. And I think both, neither parents like not having any physical custody and just having that name of visitation. So generally with our clients, that's not the appropriate way to go, although you can, it's not necessarily wrong. But to do more of a joint legal, joint physical, again, we handle 100% amicable, cooperative clients. And then in doing so, the settlement agreement can have any nature of agreement in there. It could be 100% custody to one spouse and 99 to one and 1% to the other. It could be 50-50, but it doesn't have to be that way. All these other forms, when you're going through an amicable divorce, these are not required. So this will be one thing that we see people that start their own divorce going through the trouble of filling all these out. And these are just different attachments for joint legal custody, parenting plan, holiday schedules. None of this is mandatory that you guys include this in the petition. We never complete these for our clients. These are never done. So you do not need to do those when you have an amicable divorce case. Okay, this section you can skip. This is just stipulations that are in here regarding child support. There's nothing, never go in here and here's an error that we see. People mark the box here and put, we waive child support. Don't do that. You can't waive child support. Don't put it in there. I've never in 10 years and thousands of cases have had to write anything in this child support section here. Spouse support. Now, spouse support is going to be what you are requesting at the time you file this. So if you know that you're going to want spouse support as a petitioner, you can mark spouse support payable to petitioner. If you are the petitioner and you know you're going to pay or you're going to agree to pay spouse support to the respondent, mark the respondent box. If you don't have, and again, these are just requests, so it's not right, wrong, or indifferent. If you guys are going through an amicable divorce, all this will be superseded by the settlement agreement. If you don't want spouse support now or ever, that's what terminate the court's jurisdiction means. So if you guys don't want spouse support now or ever, you would mark it, and you're going to want to mark it for both parties. And if you guys if you don't want spouse support now, you don't want to terminate the court's jurisdiction forever, but you may want spouse support in the future, none now, but in the future, that's what this box is referring to, and you would mark that. Okay, separate property. Okay, here's where there's a lot of issues that are created by people starting their own divorce. I told you I'd be going over the issues with you. We never indicate any assets or debts in the separate property section or the community property section on the next page. If there's none, simply mark none. But if there are assets and debts, you see how they tell you to complete this property declaration as an option. So what people think, and I get what you're thinking, is, well, I only have this much space, but we have, a lot more assets or debts that would fit in here. So I'm going to do this property declaration. I'm not going to go over this form because we're not going to be completing it, but it's basically a very detailed 4-page list of assets and debts where you'll list, your vehicles and your bank accounts, and you're going to list all this property, your values, and then you're going to attach that to the petition when you file it. My problem with that is that, and I am going to show you, my problem with that is, I'm not going to bring it up, is that you're giving the court way too much information, way more than they need for your divorce. And you're making that public record because you're now filing that with the court. So you're going to have a petition with a list of all your assets and debts, to include account numbers and year, make, model, and license plates, and your 401k and pension values. It's just too much information. So we never list assets or debts. What we generally will put in here is we'll either say to be determined, or parties intend to, we'll say something like parties intend, enter into a full written agreement, something like that. And again, remember, this is just for amicable cooperative divorce cases. This wouldn't work if you're going to end up in a default case where there's no agreement, no participation, no cooperation. You're not going to want to do this. That's a whole different way. And I'll do another video on that, because it's a whole different process doing these true default cases. We're talking about purely amicable. You do not need to list the assets and debts on the petition. So that's separate property. And separate property is going to be anything that's before the marriage or after the date of separation. I guess I should probably talk about that. So anything before the marriage is considered separate. Anything after the marriage is considered separate. Or I should say after the date of separation is separate. But again, for purposes of this, I'm telling you that we do not put any assets or debts listed on here anyway, so you don't have to worry about that. Going over to the community property, again, whether there's community property assets or debts or not, or again, we're just going to put that same language in here, either to be determined or the parties intend to enter into a written agreement on all issues, something like that. That'll be fine. Other requests, attorney's fees, again, amicable divorce cases, you're not going to be worried about who's paying attorney's fees. If you are the petitioner and you want to restore your maiden name, so if Jane Smith wants to restore her maiden name to Jane Jones, you're going to just say Jane Jones. Okay. So that's pretty straightforward. Other, we're not usually checking the other box. The only time I really only use the other box, to be honest with you, is if we're not checking any of these boxes. I will mark the other box and I will put none, because sometimes some courts, because we do deal with the 50 plus courts, counties in California, they will say, oh, you missed, we're rejecting the petition because you didn't fill out this section, even though nothing applied. So I always just put none in here. Date, your name, and you will sign this. Okay, so that was the